as the criminal cases against Donald Trump ramp up in Georgia and in New York and in the DC and in DC and in Florida, the disqualification case under Section 3 of the 14th Amendment is also moving up in the different states. So we heard last week quite a bit about Colorado Supreme Court's decision to disqualify Donald Trump from sitting on the presidential primary ballot and on any election ballot in Colorado. That case is going up for appeal. Just earlier today, the Michigan Supreme Court did not grant review of a lower court's ruling affirming the district court's ruling that the case for disqualification was not ripe yet. So, in short, while the Colorado Supreme Court finds through thorough examination that the case, this substantive case before them of whether Donald Trump has whether Donald Trump is constitutionally disqualified under Section 3 of the 14th Amendment, that question has yielded different answers in different state courts. For Colorado, they said it's just justiciable. It is not a political question, and they didn't even go into the matter of ripeness. As I have talked briefly about justiciability, I implore you to go look at that video that discusses justiciability. Justiciability is a body of sort of law, a body of jurisprudence that allows courts to skip over the substantive merits of the case and say that this case is not ready to be tried yet. That's what unripe means. It means that the case is not ready to be tried yet. And that's what the Michigan courts did. The trial court did that. The appellate court affirmed that. And now the Supreme Court of Michigan affirms that as well. But it leaves an avenue for the same groups that sued in Michigan to bring this lawsuit again to disqualify Donald Trump for the general election. So when Donald Trump becomes the GOP nominee, that's when the disqualification clause kicks in according to Michigan's judiciary. Now, as I've said before, standing, whether you have the right to bring the case, ripeness, whether the case is ready to be tried, mootness, whether the substance of the case has already been adjudicated and there's nothing left to try, whether it's a political question, and there are 6 tests for political questions, and that body of law is sort of like it hovers over the substantive matters, and courts in their own volition can bring up any of these topics if they just don't want to deal with the substance of the case. They don't want to deal with the merits of the case. And the dissent in the Michigan Supreme Court said that it would have been nice if we could have addressed the merits of the case. And but majority of the Supreme Court in Michigan said that the case isn't ripe yet. That's effectively what it said. It's not on the merits. Whereas Colorado's case is a ruling on the merits that, yes, he did engage in insurrection. Yes, he is disqualified from office. Yes, we are considering the issues of justiciability and political question. And here's the example, and here's the reason why. So these are standing on 2 sides of a river, and the factual bridge is what connects them, but Michigan doesn't want to take on the factual bridge right now. And Colorado has already taken it up. So you can say that it's conservative. You can say that the judiciary is scared of what would happen because we know what happens with any institution that stands up to Donald Trump's lawlessness. But it is not a case that is gone. It is not a case that Donald Trump has won. It is not a case that anybody has won. It is a matter that the case is just not ripe to be adjudicated. So, with that, I just want to touch up on this small topic of the Michigan Supreme Court and tell you that we should expect another lawsuit coming in Michigan around after the when the general election ballot time comes. So, with that, I like to close. I'll talk to you soon.